Picture this. You owe $22,000 in property taxes on your $300,000 home. The county forecloses, takes your entire house, sells it, and keeps every single penny, including the $278,000 that was rightfully yours? Sound like something that would happen in a corrupt third world country? Well, think again. This was happening right here in Michigan, completely legal until a few moments ago. And if you think that's outrageous, wait until you hear how a group of homeowners took on the entire state of Michigan and won using legal principles that date back to the year 1215. Section 1, the victims. This is the story of Tawanda Hall, a Southfield, Michigan homeowner who thought she was doing the right thing. When Tawanda and her husband Prentice fell behind on their property taxes, they did what any responsible homeowner would do. They set up a payment plan with Oakland County. They had children living in that house, and they weren't about to just walk away from it. But Oakland County had other plans. The treasurer ended their payment plan with the tax debt standing at $22,642 and then foreclosed on their home. Now here's where it gets truly insane. Instead of selling the house at a public auction, paying off the debt, and returning the surplus back to the Halls, like how literally every other debt collection in America works, the county just took the whole thing. They transferred Tawanda's house to the city of Southfield for exactly $22,642. The city then turned around and gave it to something called the Southfield Neighborhood Revitalization Initiative, which sounds very official and community-minded, for $1. $1. That organization then sold Tawanda's house for $308,000. Let me do the math for you. Tawanda owed $22,642. Her house sold for $308,000. That's a surplus of $285,358 that should have gone back to her. Instead, it went to line the pockets of a private company managed by the city officials. But Tawanda wasn't alone. Curtis and Coretha Lee lost their home over $30,547 in taxes. After the same shell game of transfers, their house sold for $155,000. That's $124,453 in equity that vanished into thin air. Christina Govan lost her home for $43,350 in unpaid taxes. The same organization still owns her former property today. What makes this even more galling is that Michigan law explicitly said former homeowners had no right to any of the proceeds, not even a penny. The state had basically legalized theft, and they were doing it on an industrial scale. Section 2, the shocking scope. This wasn't some administrative oversight or bureaucratic bungling. This was a systematic, state-sanctioned wealth transfer from vulnerable homeowners to connected insiders. And Michigan wasn't alone. About 12 states had similar laws on the books. The victims were exactly who you'd expect: elderly people on fixed incomes, families dealing with medical emergencies, anyone who hit a rough patch financially. In one case that made headlines, an 83-year-old man named Benjamin lost his Washington, D.C. home over a $134 property tax bill. The house was worth $197,000. Veterans, widows, immigrants, the most vulnerable people in our society were being systematically robbed by their own government. Some politicians were using the system to reward their friends and family with homes priced below market value. In Montana, before the practice was banned, local treasurers sold foreclosed homes for pennies on the dollar to preferred private investors. It was cronyism with a legal stamp of approval. Think about the incentives this created. Counties had every reason to let small tax debts pile up because they could eventually seize million-dollar properties. Why settle for $10,000 in taxes when you could wait a bit longer and grab a $300,000 house? It was like giving the sheriff the authority to keep whatever he could steal, completely perverting the justice system. Section 3, the historical outrage. Here's what makes this story absolutely fetch. This practice wasn't just morally wrong, it was a violation of legal principles that go back to literally centuries ago. We're talking about concepts that were already ancient when the founding fathers were in diapers. Let's take a trip back to 12th century England. Yes, the 1100s, back when people thought the earth was flat and dragons might be real. They're not. They understood something that apparently escaped Michigan lawmakers. When you take someone's property to satisfy a debt, you can only take what's owed to you. It all started with something called a gage, French for pledge, which was basically an early version of a mortgage. Mortgage. right? Get it? Gauge, mortgage. When someone borrowed money, they'd hand over their land as security. But English courts quickly realized that letting creditors keep the entire property, regardless of its value, was intolerably harsh. Enter the Court of Chancery, England's equity court. These judges looked beyond the letter of the law to its spirit. By 1625, they recognized that borrowers retained what they called equitable title to their property. Basically, they still owned the part that exceeded their debt. Makes sense to me. Lord Mansfield, one of the greatest English judges in history, put it perfectly in 1759. The borrower's equity of redemption is the fee simple in the land. Translation: even if you default on your loan, you still owe whatever value is left over. And this principle was so fundamental that it made it to the Magna Carta, that little document from 1215 that basically invented the concept of limited government. The Magna Carta explicitly said that a debtor's lands could be taken only to the extent necessary to satisfy the debt. When American courts got their hands on these principles, they were even more protective of property rights. They called the practice of taking entire properties to satisfy smaller debts unconscionable and draconian. One New York court said strict foreclosure had no appropriate place in a system of laws and jurisprudence, where mortgages were just security for debts. Even Chief Justice John Marshall got in on the action. In an 1808 case, he held that a tax collector had unquestionably exceeded his authority when he sold more land than was necessary to pay the tax in arrear. So, by the 1800s, this was settled law across America. Foreclosure by sale, not strict foreclosure. Sell the property publicly, pay off the debt, and return the surplus. It's not rocket science. Which makes Michigan's law even more audacious. They basically said, those 600 years of legal precedent protecting property rights of the individual citizen? Yeah, we're just going to ignore all of that when the government is the creditor. Section 4, the legal loophole. Michigan's General Property Tax Act was a masterpiece of legal gymnastics. Here's how the scam worked. First, if you fell behind on property taxes, they'd mark your property delinquent in March. If you still hadn't paid by March of the next year, the property was forfeited to the county, though this didn't actually affect the title yet. Here's the key. The county could choose whether to foreclose. It was optional. They could sit on forfeited properties and cherry pick which ones to pursue based on their property value versus the debt owed. When they did decide to foreclose, they'd file a petition with the state circuit court by June 15th. If the owner didn't redeem the property by paying all the taxes, interest, penalties, and fees, the court would enter a foreclosure judgment giving the county absolute title effective March 31st of the following year. Then comes the really creative part. The state got right of first refusal to buy the property for either the minimum bid, that's the tax debt, or the fair market value. But guess what? They always chose the minimum bid. Then cities could buy it from the state for the same minimum bid. The governmental body that ended up with the property was free to sell it at public auction for whatever they could get. But unlike literally every other foreclosure in American history, the former owner had no right to the surplus proceeds. The Michigan Supreme Court even acknowledged this was unusual, noting that the act does not provide for any disbursement of the surplus proceeds to the former property owner, nor does it provide former owners a right to make a claim for these surplus proceeds. It was a system designed from the ground up to circumvent constitutional protections by simply redefining property rights out of existence. Section 5, Enter the Lawyers. This is where our story takes a turn towards justice. Enter Christina Martin, a senior attorney at Pacific Legal Foundation, a public interest law firm that's been fighting governmental overreach since 1973. Christina discovered this practice in one of the most heartbreaking ways possible. She read about Benjamin, that 83-year-old veteran who lost his $197,000 DC home over a $134 tax bill. He was a man in the most vulnerable time of his life, widowed, struggling with dementia, and his own government just took everything from him. When Christina brought the case to her colleagues at PLF, they were initially skeptical. As Larry Saltzman, now PLF's director of litigation, explains, everyone's always thinking, there's got to be more to the story. But as it turned out, there really wasn't. Christina didn't just want to fight one case. She wanted to end home equity theft entirely. 3 years ago, she told PLF's leadership she wanted to eliminate the practice in 5 years. And I meant it, she said. I believed it because I'm at Pacific Legal Foundation and we can actually get to the Supreme Court. And that's exactly what happened. Christina's first major victory was Money LLC versus Oakland County in the Michigan State Supreme Court, which ruled unanimously against home equity theft. But Michigan counties found a workaround. They claimed that if they didn't sell the property at public auction, then technically there were no surplus proceeds to return. That's where Tawanda Hall and the other plaintiffs come in. Section 6, the federal case. In August 2020, Tawanda Hall, Curtis and Coretta Lee, and Christina Govan filed a federal lawsuit under Section 1983 claiming their Fifth Amendment rights had been violated. They argued that Oakland County had committed a taking without just compensation. The district court dismissed their case, buying into Michigan's argument that homeowners only had a right to surplus proceeds from an actual foreclosure sale. Since there was no public sale, the county just transferred the properties at their minimum values. There were no proceeds to share. But here's where centuries of legal precedent came to the rescue. The case went to the Sixth Circuit Court of Appeals, where it landed in the hands of Judge Raymond Kethledge. And Kethledge didn't just rule in favor of the plaintiffs. He wrote an opinion that was essentially a masterclass in property law history. His ruling reads like a legal thriller. He traced the concept of equitable title from 12th century England through the Court of Chancery, through the Magna Carta, through American colonial law, right up to the present day. He cited cases from the 1600s, opinions by Lord Mansfield, decisions by Chief Justice Marshall. The key insight was this: the plaintiff's right to surplus proceeds didn't materialize magically after a foreclosure sale. It existed before the sale as their equitable title, their ownership interest in the property beyond any liens or debts. As Kethledge put it, the surplus is merely the embodiment in money of the value of that equitable title. Michigan had tried to argue that they weren't taking the plaintiff's property because under state law, the plaintiffs didn't have any property interest to take. But the Sixth Court saw right through the shell game. Citing the Supreme Court's decision in Phillips versus Washington Legal Foundation, Kethledge noted that a state may not sidestep the takings clause by disavowing traditional property interests long recognized under state law. In other words, you can't just redefine property to exclude whatever you want to steal. The court found it particularly telling that Michigan recognized equitable title in every other context: land contracts, timber, mineral rights, divorce proceedings, but conveniently ignored it when the government wanted to be the creditor. Section 7, the scathing conclusion. Judge Kethledge didn't mince words in his conclusion. He noted that Oakland County had forcibly took property worth vastly more than the debts these plaintiffs owed and failed to refund any of the difference. Then came the line that made headlines across the legal world. In some legal precincts, that sort of behavior is called theft. Theft. A federal appellate judge called what Michigan was doing theft. But Kethledge wasn't done. He explained that the takings clause exists to prevent the government from forcing some people alone to bear public burdens, which, in all fairness and justice, should be borne by the public as a whole. The plaintiffs, he wrote, have patently been forced to bear such burdens here. The court reversed the district court's dismissal and sent the case back for trial. More importantly, it established a precedent that would protect homeowners across the Sixth Circuit: Michigan, Ohio, Kentucky, and Tennessee. Section 8, the bigger picture. The Hall decision was just one battle in a larger war. Christina Martin wasn't done after a Sixth Circuit victory. She had her sights set on the Supreme Court. Her vehicle was Tyler versus Hennepin County, the case of Geraldine Tyler, a 94-year-old Minneapolis woman who lost her condo over $15,000 in taxes and fees. Hennepin County sold her condo and kept the entire $40,000 in sale proceeds. On May 25, 2023, the Supreme Court ruled unanimously in Tyler's favor. Chief Justice John Roberts wrote the opinion, and his language was just as pointed as Judge Kethledge's had been. The taxpayer must render unto Caesar what is Caesar's, Roberts wrote, invoking Jesus' famous words from the Gospel of Matthew. But no more. The Tyler decision effectively outlawed home equity theft nationwide. States could no longer argue that they were just following their own laws. The Constitution takes precedence. But the work wasn't done. Christina Martin had been traveling the country working with state legislators to reform their laws proactively. Montana passed the bipartisan legislation with overwhelming support. Massachusetts, Minnesota, and other states have followed suit. As of 2025, the practice of home equity theft has largely been eliminated, though enforcement remains an ongoing battle. Section 9, the human cost. It's easy to get lost in the legal precedents and constitutional arguments, but let's not forget what this was really about. Real people losing their homes and life savings to a rigged system. Take Kevin Fair, a Nebraska widower whose wife had racked up massive medical bills before she died. When Kevin couldn't pay his property taxes, the state seized and sold his home over a $588 debt. He lost his case in state court and at the Nebraska Supreme Court. But just a few days before Christmas 2024, 6 years after losing his home, Kevin got some good news. Thanks to the precedent set by Tyler and Hall, he was getting back the title to his house. Or consider the scope of just Minnesota's theft. According to PLF, more than 4,300 properties were seized for delinquent taxes in that state alone, including over 1,200 family homes. Each one represents a family that lost everything they'd worked for because the government decided to change the rules of basic property law. These weren't deadbeats trying to avoid their responsibilities. These were mostly elderly people, families dealing with medical emergencies, veterans, immigrants, people who hit a rough patch and found themselves facing a system designed to destroy them. Section 10, the constitutional principle. What makes this story so important isn't just that justice was done for these particular plaintiffs. It's what it says about the nature of constitutional rights in America. The government loves to argue that rights are whatever the government says they are. If Michigan passes a law saying you don't own the equity in your home, then you don't own it. If Minnesota decides that all property tax debts can be satisfied by taking entire houses, then that's just how it works. But the Hall and Tyler decisions established something fundamental. Some rights exist independent of what the government says. They're not grants from the state that can be revoked at will. They're inherent in the nature of property ownership itself. The principle goes back to the founding of our country. The Declaration of Independence talks about certain unalienable rights that governments are created to secure, not to grant. The Constitution, particularly the Bill of Rights, doesn't give us freedoms. It recognizes freedoms we already have and prohibits the government from violating them. When Judge Kethledge traced the concept of equitable title back through 600 years of English and American law, he wasn't just showing off his historical knowledge, he was making a point about the deep roots of property rights in our legal tradition. These aren't new, radical concepts invented by activist judges. They're ancient principles that predate our government by centuries. Section 11, the cynical innovation. What's particularly galling about Michigan's scheme is how creative it was in circumventing constitutional protections. This wasn't some accidental oversight. It was a carefully constructed system designed to exploit vulnerable people while maintaining a veneer of legality. The genius of the scam was in the transfers. By moving properties from county to city to private entity, they created layers of plausible deniability. The county could say, we didn't profit, we just transferred it for the amount of taxes owed. The city could say, we were just facilitating community development. The private entity could say, we bought it fair and square. Meanwhile, hundreds of thousands of dollars in equity vanished into thin air. It's worth noting that some of these nonprofit organizations weren't as altruistic as their name suggested. The Southfield Neighborhood Revitalization Initiative, which ended up with Tawanda Hall's house, was described as being managed by city officials. How convenient is that? The kind of public-private partnership corruption is sadly common in local government. Officials can't directly enrich themselves without facing obvious corruption charges, but they can set up systems that enrich their friends, associates, and family members with the understanding that some of those benefits will flow back to them in various unofficial ways. Section 12, the broader legal revolution. The Hall and Tyler cases were part of a broader renaissance in property rights that's been building for decades. Organizations like Pacific Legal Foundation have been systematically challenging government overreach in areas from eminent domain abuse to regulatory takings. This movement gained significant momentum after the 2005 Kelo versus City of New London decision, where the Supreme Court allowed local governments to seize private homes and transfer them to other private parties for economic development. The public backlash was so severe that over 40 states passed reform legislation limiting eminent domain abuse. But the Kelo decision also galvanized property rights advocates to be more aggressive in challenging government seizures. The home equity theft cases were a perfect example of this strategy in action. Christina Martin and PLF didn't just win individual cases, they changed the entire legal landscape. By establishing clear precedents at both the Circuit Court and Supreme Court levels, they made it much harder for governments to engage in this kind of theft going forward. The legal strategy was brilliant in its simplicity. Instead of accepting the government's framing of an issue, they went back to its first principles. What does property ownership actually mean? What are the historical foundations of these rights? How have courts treated these issues for centuries? By anchoring these arguments in deep legal history, they've made it much harder for judges to dismiss their claims as novel or radical. You can't argue with 600 years of precedent. In the end, the Hall case proves something that's easy to forget in our cynical age. The system can work. It's not perfect, it's not fast, and it's not always fair. But when ordinary people are willing to fight for their rights, and when principled attorneys are willing to help them, even the most entrenched injustices can be overturned. That's a lesson worth remembering, whether you're facing down a corrupt county government or any other abuse of power. Sometimes the law really is on your side. You just have to be willing to fight for it. As Chief Justice Roberts wrote in the Tyler decision, the taxpayer must render unto Caesar what is Caesar's, but no more. No more, indeed.